Hello viewers, today we will discuss very interesting topics, the grey area of Information Technology Act 2000. Information technology has played very important role in the lives of people. Paper-based communication has been substituted by e-communication, and also we have new concepts such as e-governance, e-commerce, e-banking, e-contracts and so on. We can interact with anyone, anywhere and everywhere in no time. We can find valuable information while sitting at home. We can also work at any time. Further, the Information Technology Act 2000 has played commendable role in creating order in e-society in India. It helped in facilitating e-commerce, governance and e-contract, establishing supervisory bodies to supervise certifying authorities, issuing license to CS so that they can issue DSCs and ESCs to the subscribers, making consequential amendments in other existing laws so as to facilitate e-commerce and e-governance. Despite the various advantages, the Information Technology Act has certain grey areas which are as follows. First, we will discuss the very main grey areas of Information Technology Act 2000. The very first one is jurisdiction. Yes, the cyber jurisdiction or jurisdiction in cyberspace refers to a real world government power and normally existing courts authority over internet users and their activities in the cyber world. However, the Information Technology Act does not cover the important issue of the jurisdiction, which is very important legal aspect in deciding the place of filing the case. Constantly developing science and technology has endless benefits for the citizens of the growing global village. Although it has many advantages, the dark side of it cannot be avoided. The misuse of information technology for the various criminal activities is increasing day by day. Cyber offences are offences that are committed against individual or groups of individuals with the criminal motive to intentionally harm the reputation of the victim or cause physical or mental harm to the victim directly or indirectly using modern telecommunication network such as internet, chat rooms, emails, notice boards and groups and mobile phones, SMS, MMS, etc. There are numerous types of cyber crimes involving a long list like hacking, identity defect, theft, denial of services attack, virus, IPR violation, cyber terrorism, frauds, pornography, spam, drug trafficking, etc. So, email authenticity or its evidentiary value, e-record which is digitally or electronically signed could be produced as evidence. Today, email is a significant mode of communication. However, in email which is not digitally or electronically signed, moot question is whether it is acceptable as evidence or not. It is significant to note that this act is silent about this question. It does not touch email authenticity or its evidentiary value in the hands of the receiver. Then the problem involves with IPRs, intellectual property rights. Though proviso to the section 81 which is incorporated by the Information Technology Amendment Act 2008 provide that this act shall not restrict any person from exercising any right conferred under the Copyright Act 1957 or the Patent Act 1970, but does not contain special provision for the protection of IPRs such as copyrights, trademarks or patent, etc. In digital medium, today IPRs in digital medium, trademark issue in digital medium and patent issue in digital medium which remains untouched by the Information Technology Act 2000. Domain names infringement. The concept of e-commerce is mainly based upon domain name. However, this act is silent about the domain names infringement, cyber squatting, typo squatting, spamming and security of information at various levels. Then cross-border tax. In the era of globalization, international trade and taxation policies are very important. However, this act does not talk about the cross-border taxation policy at international level when the international contract is signed online. Another important issue is failure to surrender license, a non-cognizable offence. According to section 33 of the Information Technology Act 2000, when license of the certifying authority is suspended or revoked, then he must immediately surrender his license to a controller. However, where such certifying authorities fails to surrender license, then he shall be guilty of an offence and shall be punished with an imprisonment which may extend to 10,000 rupees or both. Further, under section 77B, which is incorporated by the again Information Technology Amendment Act 2008, any offence punishable with the imprisonment of 3 years or above, all shall be cognizable. Therefore, failure to surrender license under section 33 is non-cognizable offence. However, license is the backbone of DSCs or ESCs because only licensed CA can issue DSCs and ESC. Therefore, where a CA whose license has been revoked or suspended, if fail to surrender his license, then it should be cognizable offence. Then we will discuss the identity theft. Identity theft worldwide is a growing problem. IT Act 2000 failed to address this issue. This is the major drawback considering the fact that majority of the outsourcing work that India does requires the companies in India to ensure there is no identity theft. In fact, identity theft was one of the main reasons for major hue and cry over an incident involving personal information of UK customers on an Indian web marketing company. Then, data protection in internet banking. Like data protection laws primarily aim to safeguard the interest of the individual whose data is handled and processed by the others. Internet banking involves not just the banks and their customer but numerous third parties too. Information held by the banks about their customer, their transaction, etc. change had several times. It is impossible for the banks to retain information within their own computer network. So, high risks are involved in preventing leakage or tampering of data, which asks for adequate legal and technical protection. India has no law on data protection, leave alone a law governing an area as specific as protection of data in electronic banking. The Information Technology Act talks about the unauthorized access, but it does not talk about maintaining the integrity of customer transaction. The Act does not lay down any duty upon the banks to protect the detail of the customers and clients. UK has a data protection law which was enacted 18 years back, that is in 1998, under which banks or any person holding sensitive information may be held liable for damages if it fails to maintain adequate security protection in respect of data. In India, a bank's liability would arise out of contract as there is no statute on this particular point. Then only broad kind of cyber crimes and contraventions are covered. The Information Technology Act 2000 covers only broad kind of cyber crimes and contraventions. There were only 10 offences initially under IT Act 2000. However, increased use of technology by the criminals made it necessary to increase the number of cyber offences under this act. Accordingly, by the Information Technology Amendment Act 2008, 30 new cyber offences were inserted, whereas 7 existing offences were substituted. It is important to note that the various crimes like cyber stalking, violating privacy of a person, cyber terrorism, receiving a retaining stolen computer resource, and offences against computers are made punishable by the Information Technology Amendment Act 2008. Further, using communication device for committing any offence is also punishable. However, falling loopholes regarding cyber offences are still there. The term cybercrime and cyber offences as such is not defined under Information Technology Act 2000. Offences mentioned under the Chapter 13 are not exhaustive. No illustrations or examples of such offences are given. Some offences like chat room abuses, watching pornography websites are still not covered. Then the lack of international cooperation is a very major issue. Due to the lack of international cooperation, cyber crimes cannot be handled by isolated national efforts within the physical boundary of a country. Hence, there is a need of international cooperation in a proper handling of cyber crimes. The lack of international agreement on cybercrime and terrorism is threatening efforts to bring terrorists to the justice, said a report released this week by the United Nations Office on Drugs and Crime. Nations should consider a universal agreement requiring countries to cooperate with each other during cybercrime and cyber terrorism investigations. The report said the absence of such an agreement is an impediment to effective international cooperation in some terrorism-related investigation and prosecutions. The report said an agreement should impose specific obligations on nations. The report said the report focused on cyber terrorism, said terrorist groups are using the internet to distribute propaganda, to recruit members and to incite violence. The report said the internet make it easy for an individual to communicate with relative anonymity quickly and effectively across borders to an almost limitless audience. The report said, so there is a need of international cooperation in cyber law. The issue of cyber war has also not been discussed in this particular act. International law is an important part of any legal regime, and due provisions need to be made in concurrence of the international framework of laws. India in recent times has faced a number of cyber attacks from China, and Chinese hackers have overridden the firewalls on Indian database like Mongol army on rampage. In the 26/11 attacks, a number of classified data were provided as intel to the preparators from neighboring nation conspiring against India. There are no provision in this act to make such preparators liable for their action. Then important documents such as power of attorney etc. are not covered under this particular act. This is the major loophole of IT Act 2000 is that it is not applicable to the various documents covered under schedule. However, important documents such as power of attorney, will, trust, any contract for sale of immovable property and a negotiable instrument are mentioned under Schedule 1, hence not covered under IT Act 2000. Therefore, where e-contract relating to immovable property is formed or will is made in electronic form, then Information Technology Act shall not be applicable. Then statutory bodies may not accept electronic documents. Statutory bodies are not bound to accept electronic documents under IT Act 2000. It is significant to note that Section 9 is the biggest loophole of Information Technology Act 2000. On the one hand, the main aim and objective of the Information Technology Act 2000 was to facilitate e-governance. However, on the other hand, Section 9 provides that no one can insist any government office to interact in electronic form. Suppose Mr. A wants to submit any form and document to any government office in electronic form, or Mr. A wants to receive an certificate or document from the government office in electronic form, where the government department refuses to take or give that document in electronic form. No action can be taken by Mr. A against that government office. However, one view for introducing section 9 is that during this transactional period, government offices would take some time to keep pace with technology. It is important to note that this act was enacted in 2000 and more than one decade is over now. So now it's right to implement this act by providing sufficient training to the government and police officials, and accordingly section 9 should either be abolished or diluted, and it should be made compulsory for the government bodies to accept electronic documents. Then the no parameters for implementation is again a major issue in 2000 Act. This act does not lay down the parameters for its implementation. In India, government and police officials are not computer or technology expert. Even judges are not fully sensitized to the technology. Therefore, the question of implementation of Information Technology Act 2000 does not arise. Therefore, for the proper implementation of this act, there must be sensitization of judiciary, police officials to the technology. Then the major issue of cyber pornography. Cyber pornography is in a simple words defined as the act of using cyberspace to create, display, distribute, import or publish pornography or obscene materials with the advent of cyberspace. Traditional pornography content has now been largely replaced by online digital pornographic content. Cyber pornography is banned in many countries and legalized in some. In India, under Information Technology Act 2000, there is a grey area of the law where there is not prohibited but not legalized either. Under section 67 of the Information Technology Act 2000, make the following acts punishable with imprisonment up to 3 years and fine up to 5 lakhs. The one is publication, which would include uploading on a website, WhatsApp, group or any other digital portal where third parties can have access to such content. Then transmission. This includes sending obscene photos or images to any persons via email, messaging, WhatsApp or any other form of digital media. Then causing to be published or transmitted. This is a very wide terminology which would end up making the intermediary portable liable, using which the offender has published or transmitted such obscene content. The intermediary guidelines under the Information Technology Act put an onus is the burden of proof on the intermediary service provider to exercise due diligence to ensure their portal is not being misused. Section 67 of the Information Technology Act makes publication, transmission and causing to be transmitted and published in the electronic form any material containing sexually explicit act or conduct punishable with imprisonment up to 5 years and fine up to 10 lakhs. An understanding of these provisions make the following conclusion about the law of cyber pornography in India extremely clear. The very first one is viewing cyber pornography is legal in India. Merely downloading and viewing such content does not amount to an offence. Then publication of pornography content online is again illegal. Storing cyber pornography content is not an offence. Transmitting cyber pornography via instant messaging, emails or any other mode of digital transmission is an offence. In a very recent case, a 21 years old engineering student was arrested by sending obscene pictures by WhatsApp to a woman. In the infamous Bazi.com case, the CEO Avinash Bajaj was arrested for an advertisement by a user to sell the DPS sex scandal video. The video was not uploaded on the portal despite the Avinash was arrested under section 67 of the IT Act. It was subsequent to this case that the intermediary guidelines were passed in 2011, whereby an intermediary's liability would be absolved if they exercise due diligence to ensure obscene content is not displayed on their portal. However, there is one case in which viewing cyber pornography is punishable with imprisonment up to 5 years and fine up to 10 lakhs, where the content contains children engaging with one another with adults in sexually explicit acts. Browsing or downloading child pornography online is also punishable offence under the Information Technology Act. The creation of child pornography is also punishable under this particular act. The act of collecting and storing cyber pornography is not an offence, but if the content involves minor, then it is punishable with imprisonment up to 5 years and fine up to 10 lakh rupees. World over, online child pornography is illegal. One of the biggest publicized catches of child pornography preparators was launched in May 2002 and called Operation 1. After the FBI assessed the credit card details, email address and home address of thousands of pornographers assessing a British child pornography site, the particulars were given to the British police for investigation. The arrest of a computer consultant in Texas led to an international investigation that jailed Thomas Reddy for 1335 for running the pornography ring. About 1,300 other preparators were also arrested, including teachers, child care workers, social workers, soldiers, surgeons and 50 police officers. As a result of 40 children, 28 of them were in London, were placed under protective care. To conclude, I must say that cyber pornography has not been legalized in India. However, its browsing has not been prohibited either except in the case of child pornography. Many of the changes proposed might not be accepted to the legal fraternity, but I feel that these changes will be strongly felt in the near future. I felt that this legislation overall is a masterpiece, but the lacuna it has is the only due to the lack of technical skill while drafting. I would again insist of these proposed changes to realize in toto the purpose of enacted of this statute. Thank you viewers for watching this program.